And sometimes you'll see pushback from the federal government as to whether we have standing in those cases. So that's an issue that can arise. Of course, with this many states, there are a lot of places that we can file. And so that's a decision we make case by case as well.
How do states like Wisconsin push back when they believe the federal government has overstepped its authority? And what role does our own Department of Justice play in those legal battles? Hi, I'm Peter Kramer, Digital Communications Coordinator for the State Bar of Wisconsin. This June, the State Bar of Wisconsin's annual meeting and conference returns to Madison, and among this year's featured sessions is a keynote conversation with Wisconsin Attorney General Josh Kaul, exploring the growing wave of multi-state litigation against the federal government. Attorney General Kaul leads the Wisconsin Department of Justice, whereas he has overseen legal action on a range of issues from combating the opioid epidemic to consumer protection. Before being elected in 2018, he served as a federal prosecutor and worked in private practice. In this special preview of AMC, we sit down with Attorney General Kaul to learn more about the DOJ's involvement in multi-state cases, how these lawsuits take shape, and why they matter to Wisconsin lawyers across all areas of practice. Whether you're in private practice, public service, or corporate counsel, this is a conversation you won't want to miss. Welcome, Attorney General Kaul.
Thank you.
Okay, so Attorney General Kaul, I'm wondering if maybe you could just begin by giving us a brief overview of what multi-state litigation is and how it functions when states collectively challenge federal government actions.
A big part of what we do at the Department of Justice is work together with other state AG's offices around the country. That is part of the regular process that our offices engage in certain areas. An example is consumer protection, where there are certain actions taken by companies that operate all over the country, and having the AG's offices work together can allow us to pool resources and to get one resolution nationwide rather than a series of resolutions all over the country. There are other areas as well where we work together across states and on a multi-state basis. Some of those work in a national bipartisan fashion, and sometimes they happen with subsets of AGs. What we've seen during the Trump administration is that some of the AGs have been working together, and we have challenged a number of different policies or actions by the Trump administration. That involves collaboration among our offices, and you'll often see many states together filing a single suit. Though sometimes it happens a little differently. In some cases, there will be two groups of states that file suits. But ultimately, it's about working together, conserving resources, ensuring that the best arguments are being made, and that the litigation process happens efficiently.
So at the upcoming State Bar of Wisconsin annual meeting and conference, you plan to cover some of the recent multi-state cases in which the Wisconsin Department of Justice is involved. I know you're spending an entire session on that, but I was just wondering, can you give us sort of a brief sneak peek of what you plan to cover? And maybe it could be just describing one or two of the cases, their focus, and maybe what some of the outcomes may mean for Wisconsinites more broadly.
Yeah, well, there are a lot of these cases. As of May 14th, we're involved in 18 multi-state litigations against the federal government. And so there are a lot of different topics that have come up. One case that is of interest to a lot of folks, it relates to birthright citizenship. One of the things that was impacted by an executive order issued by President Trump right when he took office was a change in policy that would narrow the scope of birthright citizenship. We and a number of other states have challenged that. There are actually two cases challenging birthright citizenships, the change to birthright citizenship right now. There's going to be an argument soon at the U.S. Supreme Court regarding an aspect of that case having to do with the issuance of nationwide injunctions. But there's also the substantive issue as to whether what the Trump administration has done is constitutional and whether it's legal under federal law. Another area where we're seeing a number of cases has to do with efforts to largely dismantle agencies that were created by Congress. There are a few different cases along those lines. One involves AmeriCorps, another involves the Department of Education, and then still another involves the Department of Health and Human Services. And the actions the Trump administration has taken are a little different from agency to agency, and the scope of the changes they're making are somewhat different. So in each of those cases, there are various issues raised as to whether, with the changes being made, they're going to be able to meet their statutory obligations for those agencies, and whether they're making changes in a way that comports with federal law. So, for example, whether reductions in forces that are taking place, or RIFs, have been conducted in a way that's consistent with the requirements under federal law. So in a lot of these cases, there are multiple legal issues being raised, and those are just a few of the many that have come up in these different cases.
So, how does your office decide whether to join or initiate a multi-state challenge? What kinds of factors influence that decision?
Well, there are basically two factors we look at in deciding when to file a multi-state suit. So first, is the policy at issue, or the action that we're potentially challenging, is it harmful to Wisconsinites? If there's not a harm to the people of Wisconsin, there's no reason for us to be involved in that case. And so if there is a harm, then the second question is there a sound legal basis for bringing this challenge? It doesn't make any sense for us to get involved in cases if we're not going to be successful. It doesn't do any good for Wisconsinites. So that involves looking at the substantive claims that may be brought, but also it often involves considering whether we have standing to bring a suit in that case. In many cases, there is an impact to Wisconsinites, but there may not be standing for us because the state as an entity isn't harmed. But if the state is harmed as an entity, then we do likely have standing. So that's part of the calculus in determining when we'll bring a suit. So those are the two factors. Is there harm to Wisconsinites, and is there a sound legal basis for bringing suit?
I was hoping then that you would share with us a little bit about the complexities involved especially in coordinating litigation across multiple states. How does that work, and what are some of the unique procedural hurdles that might be involved with that?
Well, a lot of the complexities are practical or logistic complexities because we've got multiple states. Some of these cases involve more than 20 states. And so coordinating among our offices so that we're working jointly and we put together a collective product is important, but it's also, like I said, it's a logistical challenge. So we have regular communication. The AGs ourselves are directly in communication regularly. But in addition to that, there are members of our staff who are regularly in communication, including members of these individual case teams. Generally speaking, there are a few states that take the lead and they do a lot of the work in an individual case. But these really are collective efforts. Even if one or a few states are leading, we want to make sure that Wisconsin's perspective is represented in this case. And so we may be involved in drafting declarations or providing feedback on briefs. But that process happens collaboratively. And then the states that are taking the lead work to incorporate all that and ensure that the perspectives of the states are reflected when they're submitting case filings.
So then kind of related to that, it probably gets to those procedural issues that you kind of raised. How do these lawsuits typically move through the courts?
Well, yeah. So first, on your point on procedural issues, each state, ought to have standing. There's case law about how only one plaintiff needs to have standing, but generally speaking, we all try to lay that out. And sometimes you'll see pushback from the federal government as to whether we have standing in those cases. So that's an issue that can arise. Of course, with this many states, there are a lot of places that we can file, and so that's a decision we make case by case as well. And then in terms of how some of the substantive issues arise, or how the procedure goes forward in court, there often is a motion for a temporary injunction. A lot of these cases involve the federal government trying to take action very quickly, and we want to stop that action from happening. So, for example, if there's going to be a stop in funding that might impact existing programs, we may seek a TRO to stop that funding cut from going into effect. In almost all of the cases, maybe ultimately will be all of them, there's a motion for a preliminary injunction to try to block during the pendency of the case, the case from going into effect, for the policy change from going into effect. There have been appeals of many of those preliminary injunctions, at least a few of them. I think there will be more as those cases move forward. And then ultimately, these are generally speaking cases where there's going to be a decision based on the arguments made. Factual development could be relevant in some of these cases, but in a lot of them, the facts are not that contested. And so these are really pure questions of law. And so I think you're going to see a lot of decisions either on motions to dismiss or summary judgment that are then appealed. But primarily right now, because a lot of these things are happening quickly, it's been in these preliminary filings and preliminary orders that a lot of the action has been happening, and where there have been appeals, what the basis for the appeal has been.
So you're speaking to a gathering of Wisconsin lawyers and judges. So I want you to kind of underscore then, why is it important for Wisconsin lawyers to understand the dynamics of multi-state litigation? What kinds of lessons or strategies are there to be gained from these lawsuits for attorneys more broadly?
Well, first of all, I think that these are some of the most significant cases in the country right now. These involve major policy changes, and what happens with these policies is going to have a huge impact on a number of people. So the significance of these cases is clear. This also goes to some degree to the strength of the rule of law and the role that the executive branch in particular plays in our system of government. The Trump administration has asserted some very aggressive theories about their Article 2 authority. And in a lot of these cases, we're challenging their ability to do that, whether it's because we've alleged that they have not complied with the requirements of the Administrative Procedure Act or statutes that bind them. The Trump administration is asserting very broad power here. And to what extent courts are a check on that power, and to what extent these lawsuits are able to hold the line against these actions that are being taken, that's going to shape, I think, how the rule of law is viewed in this country. And then this is also about critical separation of powers issues, whether the federal government has broad authority to compel states to take action, which has come up in some of our cases where federal funding has been threatened to be withheld, and whether the executive branch is able to largely ignore statutes that were passed by Congress. And an issue that has not come up in our cases yet, but that may, is to what extent the executive branch will ultimately feel bound by court orders. We've had an issue come up in one of our cases involving the Trump administration's attempt to freeze federal funding, where we've gone back to court with orders seeking enforcement of the court's order, and we've been successful so far. But seeing how courts work to ensure that their orders are complied with, I think, is going to be a critical issue in these cases as well. So
what should attorneys who are attending then kind of expect to gain, do you feel, from your upcoming keynote presentation?
Well, I think they're going to hear about some of the cases that we as a state are involved with and some of the significant policy issues at stake. You're going to hear a bit about some of the legal challenges that have come up, both involving separation of powers and federal statutory issues. And you're going to hear some discussion about where we are with respect to the separation of powers and the impact that these cases are going to have on the delicate balance of power between different parts of the federal government and between the federal government and the states.
Well, Attorney General Josh Kaul, thank you so much for joining us. It's going to be a great session, very fascinating and timely topic. And we hope Wisconsin's legal community will come out and check out the State Bar of Wisconsin's annual meeting and conference and see your session in particular.
Thanks. I'm looking forward to it.
Thanks.